Of TCC Judgment 112 宪判 4, 2023, case on the constitutionality of barring the party solely at fault from petitioning for a divorce decree. Hand notes: the Taiwan Constitutional Court (TCC) upheld the constitutionality of the proviso of Article 1052, Paragraph 2 of the Civil Code and ruled that, barring the sole at fault party from filing a divorce lawsuit on the ground of the occurrence of a gross event that rendered the marriage hard to maintain, passive rule of irretrievable breakdown of marriage is in accordance with the freedom of marriage under Article 22 of the Constitution on enumerated rights. In principle, however, it may violate the freedom of marriage under the Constitution if a solely at fault spouse is indiscriminately barred from petitioning for a divorce regardless of the duration of the fault, and whether it would be draconian to that spouse in certain cases. The TCC requests the competent authority to amend the provision as appropriate within a 2-year grace period. If the amendment was past due, courts may adjudicate relevant cases following this judgment. Background note: there are 3 petitioners in this case, one of whom is a judge at the Kaohsiung Juvenile and Family Court, and the other 2 are plaintiffs of dismissed and finalized divorce cases. The judge petitioner lodged 7 constitutional reviews for the cases she was hearing. The petitioner argued that by restricting the at fault party's right to petition for a judicial divorce decree, the proviso of Article 1052, Paragraph 2 of the Civil Code contravened its original racial legend of introducing divorce on the ground of an irretrievable breakdown of marriage. Irretrievable breakdown of marriage is called 破绽主义 in 1985, consequently infringing the rights, the people's freedom of marriage. The petitioner's cases were consolidated and later argued on November 15, 2022. The TCC announced this judgment on March 24, 2023. Summary of the judgment holding: Article 1052, Paragraph 2 of the Civil Code stipulates that either the husband or the wife may petition for a judicial decree of divorce upon the occurrence of any gross event other than that set forth in the preceding paragraph that renders it difficult to maintain the marriage, except if either the husband or the wife is responsible for the event. Only the other party may petition for the divorce. In principle, the proviso of said article, which barred the solely at fault party from suing for divorce, did not violate the freedom of marriage under Article 22 of the Constitution. However, the proviso may be draconian in individual cases because it ripped the solely at fault party off the opportunity to file for a divorce lawsuit without distinguishing whether the gross event had happened or has continued for a period. Within this scope, the article violated the protection for freedom of marriage under the Constitution. The competent authority shall amend the article as appropriate within 2 years. If the amendment is past due, courts may adjudicate the cases following this judgment. Reasoning: 1. Rights pertaining to this constitutional review. The dissolution of marriage is an important part of the institution of marriage. The Constitution's protection toward the freedom of marriage not only includes the freedom to marry and maintain one's marriage, but also should include the freedom to dissolve marriage, i.e., when and whether to break out of a marriage. Either spouse's freedom to divorce should be protected by the Constitution even when they did not reach an agreement to divorce. The protection of freedom of marriage is not simply a protection provided by the defensive function of the basic right to personal freedom. It still depends on the state's regulation and the design for the institution of marriage, which should provide the people with the opportunity to file for a judicial decree of divorce. For the reason that the legal framework for divorce lawsuits and its statutory design involve constitutional protection toward the basic right for marriage, they should be subject to constitutional review. The disputed proviso bar the party at fault from suing for divorce, which constitutes a restriction on people's freedom to divorce after entering a marriage. The proviso meets the requirement of the protection of freedom of marriage under Article 22 of the Constitution. Moreover, since the freedom to maintain a marriage and the freedom to divorce both fall under the category of freedom of marriage, there might be a conflict of rights that require balancing. 2. In principle, the disputed proviso does not violate the protection of freedom of marriage under Article 22 of the Constitution. In addition to the ground for suing for divorce listed in Article 1052, paragraph 1 of the Civil Code, and on the premises of the gross event that renders the marriage difficult to maintain, the disputed proviso expressly excluded the party solely at fault for the gross event to sue for divorce. The proviso does not apply to situations where both parties are at fault. This is important here. I say it again. The proviso does not apply to situations where both parties are at fault. The legislative purpose of this proviso is to strengthen the non-fault party's self-determination right to maintain or dissolve a marriage in the aforementioned situation. By preventing marital orders from being compromised by arbitrary divorce lawsuit, the disputed proviso may safeguard the legal order of marriage and the people's sense of justice. In cases where the children's best interests should be called into consideration, the disputed proviso also serves the function of protecting the marital family and its social responsibility. The proviso's purpose is legitimate. The current civil code allows multiple grounds to petition for a judicial decree for divorce. The legislators should have room for legislative discretion in drafting relevant regulations. The state inevitably faces the issue of competing rights, conflicting rights, and the question of which to prioritize in a situation where spouses did not reach an agreement on whether to maintain the marriage or dissolve it. To safeguard the legal order of the marriage and the people's sense of justice, the proviso chooses to protect primarily the non-default party's right to maintain marriage and restrict the solely at fault party's right to initiate a divorce lawsuit when gross event rendering the marriage difficult to maintain occurs. In principle, the proviso does not violate the Constitution's protection toward the freedom of marriage. Third, in exceptional cases, the disputed proviso might be draconian. Marriage is highly personal. The reason that causes a breakdown of marriage usually accumulates over time, with a variety of contributing factors and degrees of responsibility. Under the current institution of a divorce lawsuit, when an irretrievable breakdown of marriage occurs and one of the spouses is no longer willing to maintain the marriage, what the disputed proviso protects is usually an external formality of the marriage in which the substance of mutual love and the mutual act is already lost. The disputed proviso, without distinguishing whether the gross event had happened or has continued for a period, bars the solely at fault party from filing divorce lawsuits and practically ripping them of the opportunity to divorce. Said practice might be excessive in individual cases. Within this scope of excessive cases, the proviso may contradict the Constitution's intention to protect the freedom of marriage. The competent authority shall amend the article as appropriate within 2 years. Courts may adjudicate cases following this judgment if the amendment is past due. As to how long since the occurrence of the gross event should be, or how long should it have continued, the issue should fall within the legislative discretion and not this judgment's scope of review.